General Preliger.
Mr. Chief Justice, and may it please the Court, EMTALA's promise is simple but profound. No one who comes to an emergency room in need of urgent treatment should be denied necessary stabilizing care. This case is about how that guarantee applies to pregnant women in medical crisis. In some tragic cases, women suffer emergency complications that make continuing their pregnancy a grave threat to their lives or their health. A woman whose amniotic sac has ruptured prematurely, for example, needs immediate treatment to avoid a serious risk of infection that could cascade into sepsis and the risk of hysterectomy. A woman with severe preeclampsia can face a high risk of kidney failure that could require lifelong dialysis. In cases like these, where there is no other way to stabilize the woman's medical condition and prevent her from deteriorating, EMTALA's plain text requires that she be offered pregnancy termination as the necessary treatment. And that's how this law has been understood and applied for decades. That usually poses no conflict with state law. Even states that have sharply restricted access to abortion after Dobbs generally allow exceptions to safeguard the mother's health. But Idaho makes termination of felony punishable by years of imprisonment unless it's necessary to prevent the woman's death. I think I understood my friend today to acknowledge several times that there is daylight between that standard and the necessary stabilizing treatment that EMTALA would require. And the Idaho Supreme Court recognized the same thing when it specifically contrasted the necessary to prevent death exception and said it was materially narrower than a prior Idaho law that had a health exception that tracked EMTALA. The situation on the ground in Idaho is showing the devastating consequences of that gap. Today, doctors in Idaho and the women in Idaho are in an impossible position. If a woman comes to an emergency room facing a grave threat to her health, but she isn't yet facing death, doctors either have to delay treatment and allow her condition to materially deteriorate, or they're airlifting her out of the state so she can get the emergency care that she needs. One hospital system in Idaho says that right now it's having to transfer pregnant women in medical crisis out of the state about once every other week. That's untenable, and EMTALA does not countenance it. None of petitioners' interpretations fit with the text, and so they have tried to make this case be about the broader debate for access to abortion in cases of unwanted pregnancy. But that's not what this case is about at all. Idaho's ban on abortion is enforceable in virtually all of its applications. But in the narrow circumstances involving grave medical emergencies, Idaho cannot criminalize the essential care that EMTALA requires. I welcome the Court's questions.
General, are you aware of any other spending clause legislation that preempts criminal law?
With respect to criminal law in particular, Justice Thomas, I'm not immediately thinking of relevant cases. We have a whole string side of cases in our brief at page 46 that reflect times where the Court has recognized the preemptive force of spending clause legislation, including in situations where the funding restrictions apply to private parties, so that could include the Coventry Health case, for example. Lee Deadwood is another example of this, but I'm not immediately recalling how that would apply in criminal law. Of course, this Court hasn't drawn those kinds of distinctions in recognizing the force of the supremacy clause.
Now, normally when we have a preemption case, it's a regulated party who is involved in a suit, and they use it as an affirmative defense, for example, in Wyeth or something. In this case, you are bringing an action against the state, and the state's not regulated. Are there other examples of these types of suits?
Sure. I mean, there are numerous examples where the United States has sought to protect its sovereign interests in situations where a state has done what Idaho has done here and interposed a law that conflicts. So I'd point to Arizona versus United States as an example of that, United States versus Washington. There are a number of cases where this Court has recognized that the federal government can protect its interests in this kind of preemption action. And as I'd mentioned before, the Court has a long line of cases recognizing that that preemption principle applies in the context of federal funding restrictions that apply to private parties, too.
But even when the party that you're bringing the action against is not a regulated party?
That's correct, because what Idaho has done here is directly interfered with the ability of the regulated parties who have taken these funds, federal funds with conditions attached, from being able to comply with the federal law that governs their behavior. Now, this was an essential part of the bargain that the federal government struck with hospitals in substantially investing in their hospital systems. And what the state has done is said, you, through our operation of state law, are no longer permitted to comply with this fundamental stabilization requirement in EMTALA in this narrow category of cases.
Well, normally, wouldn't it be the regulated party that would actually be asserting the preemption that you're talking about?
Certainly, I can imagine situations, for example, where a regulated party would assert a preemption defense and to say the state law itself is preempted to the extent that it prevents that party from being able to comply with federal law. But I'm not aware of any principle or precedent in this court's case law to suggest that that's the only way for the government to protect its sovereign interests.
That is the normal way, though.
I think that that's often the fact pattern of particular cases.